Welcome back, folks. I'm Avi Socha, and this is Further Study Family Law, where we explore the laws that shape families one topic at a time. Today, we're going to be diving into the solution to many, but not all, of the problems I've highlighted with divorce: nuptial agreements. Nuptial agreements are private contracts that govern the terms of financial separation. They can cover a wide variety of topics, subjects, terms, and conditions. We'll be talking about what exactly they are, what's usually included, how they help you, and why you should have one before you get married. In this episode, we will explain some usual rules of thumb and commonalities across the union, but please consult a local attorney for what your judges will accept. Again, don't get legal advice from YouTube. We think this requires further study. Nuptial agreements are just that, agreements. A private contract between you and your spouse that governs various aspects of your lives while you are married, or dictates parts of your separation if you get divorced. This can mean anything from who keeps what debt, who gets to keep certain property, who gets the house, or dog, or car, or PS5, etc., or what, if any, alimony a party should receive when you part ways. There are two nuptial agreements commonly seen in law: prenuptial agreements and postnuptial agreements. The distinguishing factor is simple. A prenup is agreed to before marriage, and a postnup is agreed to after. For an agreement to be legally binding, it has to have what is called consideration, an exchange of material value between the agreeing parties. In a prenup, an agreement made before marriage, the consideration exchange is the marriage itself. Easy. In a postnuptial, you already tied the knot. If you're negotiating a postnup, you'll actually have to give something up to make it enforceable. Maybe it's a monthly payment, or maybe it's a certain amount of alimony guaranteed, or maybe it's a greater share of the assets upon separation. Maybe your spouse gets the right to use the shower first in the morning for the length of your relationship. Whatever it ends up being, what I really want to highlight here is that nuptial agreements can be negotiated at any time before or during a marriage. The government allows this because you have a constitutionally protected right to enter into a contract as a private party. That right is often subordinated to the government's police and regulation powers, but sometimes it wins out. There are certain guardrails the courts put in place to make sure things don't go completely crazy. More on that in a moment. But I find it comforting that we as adults are largely free to decide what is fair in our own relationships, even if it means we never get to shower first in the morning. Famously, when Melania Trump and Donald Trump were married in 2005, they entered into a nuptial agreement. In fact, they've had several. Vanity Fair and Page 6 have reported that Melania renegotiated her nuptial agreement 3 different times during their marriage. 3 different times so far. Why? To ensure there was enough money for her and her son Barron Trump to start over should Big Donnie's legal troubles ever really catch up with him. I highlight this because the Trumps are a great, real-world example of how many people fear they will be perceived when negotiating a nuptial agreement. They don't want to be seen as a motionless gold digger who's only marrying their spouse for the money, or in the alternative, as a greedy golden toilet miser only looking to protect his money from his younger, poorer spouse so he can dump her at will. For the Trumps, that may be precisely what's going on. I won't disagree with you. But I also want to provide another perspective. Whether you were married in the US or elsewhere, anyone who divorces in these United States will be subject to the one-size-fits-all separation terms the government has pre-planned for you. Or to put it another way, you already have a nuptial agreement, whether you want one or not. Do you trust the government so completely that you're okay throwing yourself on its mercy? To decide just about every major detail of your post-separation life? Or might you want to check its work and arrange something better suited for your needs? If you are worried that having a conversation about your finances might ruin your existing relationship, then maybe your relationship is already on shaky ground. Ask yourself, how are you supposed to talk about buying a car or a house if you can't even talk about who will get the commemorative Baby Yoda cups in the event of a divorce? Discussing what might happen in the future isn't inviting separation any more than wearing a seatbelt invites a car accident, or wearing garlic invites vampires. An understanding and respectful partner will know that. For myself, I definitely plan to have a prenup when I get married. I want my partner and I to have that conversation when we're in a good mood, not when we're actively fighting. It's better for everyone that way. You're probably wondering what specifically can be included in a nuptial agreement. Generally, most financial matters. This includes, but is not limited to, property rights and obligations for each spouse during and after the marriage, rights to retirement accounts and life insurance policies, spousal support obligations and duration, division of property among children from prior relationships, or even estate considerations. The sky is the limit. The utility here is that everyone gets certainty on the terms of a potential separation, and it limits liability of one spouse or the other. Most importantly, it will save you a lot of money in attorney's fees. Maybe $5,000 for a prenuptial negotiation versus $150,000 to pay me to argue over your furniture. Think of that $5,000 as a serious investment. Before we move on, I want to draw attention to the fact that you can put a lot of stuff in a nuptial agreement, but that doesn't mean it's all enforceable. Some things are off limits. As a general rule, you cannot determine child support or child custody matters in a nuptial agreement. The reasoning being that the standard of review for custody by family law courts is best interest of the child, and parents contracting amongst themselves may not meet that standard. And more practically, it is impossible to know the best circumstances for a growing child years in advance. What if your teenage child is a championship surfer, but your ex-spouse wants to move to the Swiss Alps? Should your kid have to throw away their dreams and learn to ski just because your prenup says your spouse gets custody? This surf Alp ski divorce situation doesn't happen often, but maybe it'll happen to you. You can't predict the future. Sadly, this means that there is no agreement you can write that will let you avoid a custody battle if it comes to it. You also can't write any clauses against public policy. This means that, for example, you cannot financially incentivize divorce or write any clauses that substantially prevent it. Why not? Well, it's for the same reason your prenup can't rewrite zoning laws or make murder legal. It's not your decision. As an example, you can't stop a divorce filing by mandating counseling sessions first. A court will refuse to enforce that contract. As we have said before, there is no way to stop or prevent a divorce if your spouse wants one. Similarly, you can't include any provisions that involve or encourage illegal activity, such as breaking other contracts or encouraging theft, for obvious reasons. Further, you can't include anything unfair, unjust, or punitive. The court's aim is to ensure a fair division even among private parties, and courts dislike agreements that punish a particular spouse unfairly. Keep in mind that fairness is at the discretion of the court. And finally, courts will tend to throw out any nuptial agreement that appears to be negotiated under pressure or duress. Courts know there is huge social pressure to sign, no matter what the terms are, and judges can leave the door open to throwing out a nuptial agreement if it appears rushed or lopsidedly negotiated. Everything we have covered so far is outright prohibition. Here is where my input turns a little more into opinion about what you might want to include or avoid. It may be tempting to include behavior provisions that change the distribution of assets based on behavioral factors. A very common example is an infidelity clause. It seems fair in principle, right? You cheat, you get less money during the marital dissolution. Well, while many states technically allow provisions like this, we don't usually like putting them in our clients' nuptial agreements as a practical matter. Putting an infidelity clause in your nuptial agreement shifts the nexus of dispute back in time to the 1950s, when all divorces had to be at fault. Just like perms and lead pipes, some things shouldn't exist in the 21st century. It also slows down the entire divorce process. Instead of spending your time arguing about assets, you will spend your entire case trying to prove your partner cheated in court. A nuptial agreement is supposed to make separation simpler. Turning the court system into your personal episode of Maury Povich is the opposite of simple. And what is cheating, anyways? Emotional cheating? A specific perverse act with another? Maybe furtive glances at a bar, emotional distance, playing too many video games. Watching the finale of Andor by yourself, even though you promised your partner you'd watch it together? It's a very subjective standard. If you define cheating too broadly in your nuptial agreement, then the clause becomes too vague to enforce. And if you define it very specifically, that can still end up creating endless loopholes to avoid it. And again, the intent of the clause is difficult to enforce. And what is more, nuptial agreements are civil instruments. Courts tend to frown on using them to punish behavior. It's just not what they were designed for. And you risk the court's displeasure at your peril. If your nuptial agreement is thrown out, you are right back to square one and fully exposed. I'm going to be a hater for a bit. There are a number of companies that will draft you a prenup for a few $100s online, sometimes in minutes. They are cheap, easy, and accessible. Am I going to dissuade you from using them? No. They are certainly better than nothing for most people, but oftentimes they aren't much better. You should also know that these online services are not attorneys. They do not and cannot represent you or advise you. Further, they often have no staff licensed to practice law in the state you're in, and they don't carry malpractice insurance if they make a mistake. When you have a nuptial agreement, you ultimately don't know if it will hold up until the day you try to enforce it. The 5-star reviews of these drafting services are often from people who are happy it only cost a few $100 and took 5 minutes to draft. They don't actually know if the agreement they bought is going to help them when their day in court arrives. I always recommend getting 2 local attorneys involved when drafting your nuptial agreements. It will protect each of you, now and also later, because you can be sure whatever you come up with will hold up in court. This week, we talked about nuptial agreements, what can be in them, some best practices, and why they hold certain limitations. We went over some common decisions my team makes when drafting them for our clients and our reasoning behind them. In our next episode, we'll dive into contempt. I'll see you next week. Thanks for watching this episode of Further Study, which was filmed at our studio in Toronto, Canada. Support Further Study on Patreon to keep our content free for anyone who wants to learn.